Now, a Catholic bishop who was forced by the Vatican to leave Belgium after admitting sexually abusing his 5-year-old nephew.
She claims her son was victimized by a priest years ago and eventually took his own life.
A deep psychological trauma inflicted on him by a paedophile priest.
In recent years, headlines across Australia have told a similar story. Historic abuse claims return to court decades later. Institutions face accountability for past wrongdoing. Is justice delayed, justice denied? Can justice survive the passage of time? That caused some real questions. What if the accused is already dead? What if the only evidence is memory from 50 years ago? What if the institution says we are not responsible because the wrongdoer is not our employee? And even more confronting, should the law force organizations to pay for crimes they did not commit? Or is that the only way justice can ever be done? This is the story of AA and trustee of Roman Catholic Church for the Diocese of Maitland-Newcastle. This is a case that didn't just decide liability, it reshaped the law in Australia. A case that went from victory to total collapse and back to a historic High Court win for child abuse victims. And in the process, it changed Australian law on duty of care, institutional responsibility, and liability for intentional criminal acts. Today, we will break it down step by step, and in particular analyze as parents what you should know if you entrust your children in schools and churches. Roman Catholic Church in Australia was at relevant times divided into geographic areas known as dioceses. Each diocese was further subdivided into geographic area known as parishes, and that each parish was to have its own rector as the proper pastor of that territory. Bishop of the diocese had powers of direction and control over incarnated priests. In the later 1960s, priests were given an exaggerated dignity and respect, which could and did become dangerous at times. There was minimal community awareness of the potential for abuse by priests and religious figures. In the 1960s and 1970s, priests would engage with youth of the parish by such means as youth groups, movie nights, campaign, sporting team, choir, and any number of other activities bring people together under the banner of the church. At the time, very few things were written down about how parish priests should conduct themselves, and that was left to their common sense and good judgment. The now well-catalogued tragic offending by priests was virtually unknown then, apart from those in position of high authority in church, such as bishops, religious superiors, and provincials, who were aware of complaints made. But such complaints rarely came to the attention of the general Catholic populace, and so there was minimal, if any, suspicion that a trusted religious leader could pose any kind of threat to a child. In 1969, a 13-year-old boy, referred to as AA, was studying at Watson High School. The reason we call the plaintiff AA is because there was a non-publication order made so that his name would not be disclosed for a period of 40 years. AA was born in 1955. His mother died when he was aged 8. He was a victim of domestic violence at home, and from age 5, he was given wine to drink at every meal. At Watson High School, AA met a Catholic priest, namely Father 𝗷cie𝗶H, through religious instruction at school. The priest invited boys to the presbytery, gave them alcohol and cigarettes, invited them to play poker machine, and build trust and authority. On a few occasions, AA became drunk to the point that he felt unconscious or blacked out in the bedroom. Then, according to AA, he was repeatedly sexually abused. By the time the case was brought, the priest was dead. Witness memories were decades old, and evidence was fragmented. But importantly, Australia had abolished limitation periods for child abuse claims. So the question becomes, can the church be held liable for something that happened 50 years ago? From the trial, there are a few legal issues to be resolved. Did the abuse occur? Did the diocese earn a duty of care? Is the diocese liable? And can damages be awarded? The case initially started in the Supreme Court of New South Wales. How do you prove something that happened half a century ago? The trial judge is Acting Justice Monica Schmidt, who specialized in employment law and industrial matters. She accepted that abuse did occur based on AA's testimony and is supported by tenancy evidence. Such abuse repeated multiple times in 1969, causing AA both immediate personal injury and ongoing consequential psychological harm. The pattern is that Father 𝗶𝐿 invited AA and his classmate to Presbytery on Friday night, offered them cigarettes and drinks. When AA got drunk, Father 𝗶𝐿 made up excuse to send AA's friend to buy cigarettes. The shop was around 20 minutes walk away, so this means AA would be alone with the Father 𝗶𝐿 for at least 40 minutes. On around 6 occasions, when AA was alone with Father 𝗶𝐿, he was sexually abused by the priest. Even though AA was so drunk, when it happened a few occasions, he realized it was wrong and stopped going to the Presbytery on Friday nights. It turned out that Father 𝗶𝐿 even invited AA on a holiday to Surfers Paradise in Queensland. Although AA's family was quite poor and it was a rare opportunity for vacation, AA decided not to go on the trip. The tenancy evidence also established that Father 𝗶𝐿 had a sexual interest in boys. He sought out opportunities to achieve intimacy with boys, including by using church premises for that purpose when he was able to do so. Under Section 97 of the Evidence Act, tenancy evidence is not admissible unless the court thinks the evidence will have significant probative value. The trial judge considered tenancy evidence against the Father 𝗶𝐿 had significant probative force to assess whether AA was actually assaulted as a victim. Therefore, the tenancy evidence was admitted. Through such evidence, it was found that Father 𝗶𝐿 had committed sexual assaults on other children from 1965 to 1970s, when they were only about 11 or 12 years old. In 2015, criminal proceedings were brought against another priest in the diocese for organized criminal activities within the church in 1970s and 1980s, and Father 𝗶𝐿 was specifically mentioned in the judgment. Father 𝗶𝐿 died in 2015, but he caused permanent harm to AA. AA started 7th grade at Watson High School. The classes were graded academically, and he was placed in 7A, the top stream. But because of incidents with Father 𝗶𝐿, AA left school in year 10 and had difficult life afterwards. AA later on started taking drugs from age of 15 and served a period in prison for about 12 months. Turning into an adult, he worked in Wollongong but was seriously injured in a car accident in 1979. He became bankrupt in 1995 after his retail business went down and had to live on a disability pension. In 2013, he suffered a stroke, and in 2018, he was diagnosed with motor neuron disease, which became terminal. It is difficult not to feel sympathy for a man whose life has contained so many misfortunes. AA initiated proceedings long after the 2017 final report of the Royal Commission into Institutional Responses to Child Sexual Abuses and the 2014 Cunning Report in relation to abuse by clergy in the Roman Catholic Church in the Hunter region. Such delay follows a well-known and well-exposed pattern of behavior which so many young men had endured. They commonly did not want to talk about it or make any complaint because of feeling of guilt, shame, and their fear of not being believed. So what did Justice Schmidt say? Firstly, the judge found the church was subject to vicarious liability. The church was responsible for the priest because abuse of youth was so closely connected with the priest's employment as a priest at the church that it would be fair and just to hold the church vicariously liable. The judge concluded that Father 𝗶𝐿's assignment was subject to the ultimate authority of the diocese, which had control over the priest's work, appointment, role, and duties in the parish. Therefore, the priest was not acting independently, but as a representative of the diocese. Father 𝗶𝐿, in a real and relevant sense, is the servant of the diocese, even though not in a strict legal sense an employee. Number 2, the judge found the church was in breach of duty of care. Justice Schmidt was satisfied that diocese earned AA a duty of care and failed to protect him. The diocese was aware, even in 1966, that Father 𝗶𝐿 had been complained against by other victims about sexually touching them without consent. These complaints were sufficient to put the diocese on notice of the particular risk which Father 𝗶𝐿 posed, but the diocese chose to neglect those risks. or did not take proper measures to address them. This cannot be forgiven considering the undoubted seriousness and criminality involved in such behavior. Justice 𝗷cie noted that a reasonable person in Diocese's position would have taken precautions against the risk of harm which a new parish priest, such as Father 𝗷cie, would pose to children. For example, they should have informed Catholic families of the existence of child sexual abuse as the potential risk. They should have instituted a system of mandatory reporting and proclaimed a zero-tolerance stance against child sexual abuse by any parish staff. And they should have forbidden any priest to have access to a child in his residence. But none of those precautions were taken. So what's the damages? The sexual abuse occurred in year 7. Based on expert report, it caused 𝗷ci's emotional and behavioral disturbance, which had affected his day-to-day functioning and earning powers. Under the Civil Liability Act, the maximum amount of damages which could be awarded for non-economic loss was $722,000 for the most extreme case. The trial judge then assessed the damages to be about $250,000 for non-economic loss and another $380,000 for compensation that 𝗷ci could achieve for higher earnings had the abuse not incurred. The overall amount of the compensation was calculated as $636,000. Diocese then appealed to the Court of Appeal. The Court of Appeal consisted of Chief Justice Andrew Bell, Justice Mark Leeming, and Justice Michael Ball. The appeal judges completely overturned the trial judge's decision. There is an issue as to the reliability of 𝗷ci's memory. Based on scientific studies, with the passage of time, the memory of many details fades or becomes confused. Frequently, people cannot recall when events occurred or who was present, or for example, what was said. And there is a natural tendency for people subconsciously to reconstruct those events in a way that is favorable to them. The Court of Appeal found that Father 𝗷cie was not just a parish priest, but an assistant priest. There was lack of contemporaneous documents from 1969 to 2024. One of 𝗷ci's friends, Mr. Alan Perry, was invited by Father 𝗷cie to go to presbytery and even on holidays in Queensland, as did other boys. But Mr. Perry said he never heard anybody complain about inappropriate conduct. It was said that the trial judge believed 𝗷ci's evidence over Mr. Perry's evidence without rational explanation. 𝗷ci's evidence was inconsistent, especially as to whether the events happened in 1968 or 1969. So his evidence could only be considered as genuine, but not reliable. So the Court of Appeal judges concluded that Justice 𝗷cie's fact-finding process has miscarried. The Court of Appeal also unanimously held that there could be no non-delegable duty earned by the diocese in respect of any intentional criminal act of one of its priests. So what is non-delegable duty? A non-delegable duty means you are not just required to be careful, you are required to make sure others are careful too. And if they are not, you are still legally responsible. Imagine at the school, a child is placed under the school's care, and the school hires a teacher. If that teacher harms the child, the school cannot say, "We hired someone competent, it's not our problem," because the school has a non-delegable duty to ensure the child is safe. Another example is the hospital. The hospital cannot escape liability by saying the surgeon made the mistake, not us, because patients are vulnerable. The hospital controls the system. So the law says the hospital must ensure proper care no matter what happens. The limitation has been imposed in an earlier High Court case, being New South Wales and Lepore, which also involved school children sexually abused by teachers. In that case, the court drew a sharp distinction. Negligence refers to carelessness, while intentional crime is deliberate wrongdoing. Schools should be liable for their staff's carelessness, but not deliberate wrongdoing, which are not foreseeable. The court's concern was that non-delegable duty only belonged to negligence law, not criminal wrongdoing. So the majority of the High Court judges said, you cannot stretch negligence to cover deliberate abuse. That would convert the institution into insurer of safety, which is too harsh. Then becomes a principle that there can be no common law non-delegable duty in respect of harm caused by an intentional criminal act. As a result, 𝗷ci's claim was dismissed. 𝗷ci then appealed to the High Court. The High Court, with its majority including Chief Justice Stephen Gageler, Justice Jane Jaggard, Justice Robert Beach Jones, Justice Michelle Gordon, and Justice James Alderman, reversed the Courts of Appeals decision. The High Court restored credibility of AA's evidence. The High Court considered that the trial judge's factual finding process has not miscarried. The primary judge determined the proceedings on the basis of the diocese's admissions and the agreed facts. The Court of Appeal was not in a position to determine the reliability of AA's evidence. The inconsistencies picked up by the Court of Appeal, such as different accounts of when sexual assaults occurred, were immaterial. It is not disputable based on evidence that sexual assaults did occur in mid-1969. You can say somebody has imperfect memory, but you can't say that person suffered from a delusion and that never occurred. In particular, the psychiatric report said AA maintained normal memory. It is therefore too speculative to suggest that as AA had abused drugs and alcohol in early years, there would be a large chance that he convinced himself or under a delusion that Father Pickham sexually assaulted him. Yes, people's memory may fade. However, the processing of traumatic events, such as childhood sexual abuse, is not necessarily the same. It is in the most extreme category that people tend to remember for life. It is certainly not part of everyday life to which courts can apply their own experiences. The High Court also clarified the application of non-delegable duty. The court held the diocese earned a non-delegable duty of care. Why? Because the church placed the priest in the authority. The child was vulnerable, and the church had control and supervision power. The High Court in particular sided with Justice Michael McHugh for his minority judgment in Lepore's case. Justice McHugh in that case said, "The state education authorities owns a duty to pupil to take reasonable care to prevent harm to the pupil. The state cannot avoid liability by saying that the teacher intentionally caused the harm. It is the state's duty to protect the pupil, and the liability is direct, not vicarious, and it is not confined to school hours, and the duty event extends to protecting the pupil from the conduct of other pupils or strangers, and from the pupil's own conduct." The High Court stressed that the rationale of imposing such non-delegable duty is that children and pupils are vulnerable, and it is reasonably foreseeable certain risks may be real to them. The vulnerability that adult may wrongfully exploit authority over the child would have been as obvious in the 1960s as it is today. In AA's case, from the perspective of diocese, the relationship was instrumental with the purpose of promulgation of religion, and the children are immature and easily led. Priests are expected to pay particular regard to such immaturity. The court also stressed the level of control of the church and the school. In entrusting their children's safety to the school and the priest, parents have no control over the appointment of teachers or priests or what they could do to their children. The duty is not delegable, and it is direct. It does not matter when sexual assaulting took place. Father Pickham was not in fact performing a function of the priest. It only matters that AA came to be under the care, supervision, or control of the diocese. It is always possible to criticize the duty of care as too broad or too narrow, but one has to consider this type of non-delegable duty can perfectly arise from a relationship between the diocese and the child, where extra protection is needed. The court also looked at worldwide how other common law countries treated things like this. The previous decision in Lepore restricted the court to expand the vicarious liability to independent contractors and other non-employees, in contrast to approaches in countries such as UK and Canada. This created incoherence in the common law. The court at the end said the judgment in Lepore has not led to a useful result. The case itself is problematic and should be overturned. Justice Simon Stewart and Justice Jacqueline Gleeson disagreed with the majority of the High Court and expressed concerns that institutions should not become liable simply because harm occurred. The practical consequences of extending non-delegable duty to crimes risks would turn institutions into insurers of all harm. In any event, the High Court would no doubt overturn part of the Lepore case. The time that there can be no common law non-delegable duty in respect of harm caused by an intentional criminal act is now officially over. Final result: AA wins, liability restored, but the damages had been reduced to $335,000 due to statutory limits. This case isn't just about the past, it's about the future of institutional responsibility. Schools, churches, organizations now face broader exposure. It will be interesting to see if and how the judgment could extend to other industries, such as hospitals and aged care. Victims now have stronger claims, especially for historic abuse, but there still remain forensic challenges for lawsuits on matters that happened decades ago, considering the frailty of human memory. Historical evidence will invariably be required, which may be elusive. Non-delegable duty is now much wider, even if the priest committed the crime and the church was not aware of it. The church can still be liable because they failed to ensure safety. Institutions cannot escape liability by simply saying we didn't do it if they created the risk, controlled the environment, and put vulnerable people in harm's way. Here are some final questions for you. Should institutions be insurers of safety? Does this go too far so that costs of insurance will only pass on to the parents? And if this applies to churches, should it apply to corporations and even tech platforms? If you find this video interesting, feel free to leave any comments and share to any friends. Thanks for watching. I will see you next time.